This is case number 253691 FY Appearances Council.
Joanne Carey for the people.
Troy Dean, Your Honor, appearing with Mr. Du Bois.
And we are here for a couple matters. We were originally scheduled for a preliminary examination, and then yesterday afternoon, the court received the defense's motion to withdraw as counsel. So let's address that issue first. Mr. Daniel.
Yes, Your Honor. I went to go speak with Mr. Du Bois yesterday at the Western County Jail. Attempted to go over the 3 hours of body cam videos with him. There was a disagreement as to how to go about viewing the videos, and that Mr. Du Bois then came upset and told me I could leave. And I said, okay. So I started to leave, and then he started calling me names, calling me a hack, calling me a bitch, all the way to the point where he was let out back to his cell. I believe there's been a breakdown of the significant breakdown of the attorney-client relationship pursuant to the Michigan Rules of Professional Responsibility 1.116. I don't believe I can accurately represent Mr. Du Bois in the future because of his attitude. And again, what he wanted to do, it made it really untenable to go through the process of reviewing the videos. And consequently, I feel that I have to excuse myself in the case, so that's why I filed the motion to withdraw, Your Honor.
And just so I'm clear, you believe that you can't continue to represent Mr. Du Bois because of the breakdown? All right. Ms. Carey? I'm beginning to see a pattern here, Mr. Du Bois, and that's, no, I won't say the pattern I'm seeing. But I did see in Mr. Daniel's motion that you, at least as he stated, told him that you work for me and you're going to do things my way. That's not how that works. You're not an attorney. You might think you have the legal training, but based on what I see from your criminal history, your understanding of the law has not bode well for you. So I suggest you start taking the advice of the attorneys that are appointed to represent you, because we are now, I don't know how long it's going to take to get you an attorney. I had planned on today not granting the motion, but based on what Mr. Daniel is telling me that he cannot work with you because the attorney-client relationship is broken down so much, I will grant the request. I'm sorry to the people. I think we're back here for your third time now with witnesses. I apologize. But I will grant the request. I will let Mr. Daniels out of rep. No, you and I went round and round last time. We're not doing this.
So I don't have a right to address?
Mr. Du Bois, you do not.
Okay, so I don't have a right to be heard in respects to why he's withdrawing?
No,
Because
he's telling bailiff, let's get him out of here. I'm not doing this.
Your Honor, if you may approach the
You may.
What do you mean stop? Nobody's acting aggressive or nothing.
Thank you.
What stop it off?
So they're gonna have to check you from the floor. Okay. Knock it off. So,
Ms. Wood, will you please raise your right hand? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth? You put your hand down. It's my understanding that you'll be pleading guilty to an essentially what is an added count 2 of driving while license as a first offender. I'm sorry, driving while your license is suspended, denied, or revoked as a first offender. That is a 93-day misdemeanor and or a fine of $500. In exchange for that, the people will dismiss the charged offense of driving while your license was suspended, denied, or revoked as a second offender. That is a misdemeanor punishable by up to 1 year in jail and or a fine of $1,000 and vehicle mobilization. Is that your understanding of the plea agreement?
Yes, sir.
Back on October 11th of this year, were you on probation or parole?
No.
Were you on bond?
Yes, sir.
Was there any type of bond violation for this? I don't remember there being one. All right. Do you remember reading and signing this advice of rights form? Talk about your rights to an attorney and your rights to a trial.
Yes, sir.
Did you understand those rights?
Yes.
Most importantly, do you understand that you have a right to a jury trial and that by entering a guilty plea today, you'll be giving up that right and you won't have a trial of any kind?
I do understand.
Other than the plea agreement, has anybody promised you anything in order to get you to plea today? Has anybody threatened you in any way? And is it your own free choice to plea today? Are council aware of any other promises, threats, or inducements not made part of the record?
Yeah.
No, Your Honor.
Then Ms. Wood, to the allegation that on or about October 11th, 2025, in the city of Cadillac of Wexford County, how do you plead to operating while your license was suspended, denied, or revoked as a first offender?
I plead guilty.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So were you operating a motor vehicle in the city of Cadillac on that day?
Yes, I was.
And had your license been suspended, denied, or revoked?
Yes, I
Did you know that?
did.
Do you counsel believe the defendants provided a factual basis to accept the plea and the court rules have been complied with?
Yes, sir.
Yes, Your Honor.
As does the court, I find the plea is knowing, voluntary, and accurate. Ms. Wood, I find you guilty of operating while your license is suspended, denied, or revoked as the first. Pursuant to the plea agreement, the charged offense will be dismissed. Any allocution, Mr. Hartel?
Yes, Your Honor. I would ask the court to consider this being a fines and costs situation. She has advised me that not only does she have someone to give her a ride here, someone to give her a ride back, gentleman right over there back. But she's also working towards getting her license back. It's a bit of an uphill battle. She knows she's got a few steps to do, but she does have the long-term goal of being a legal driver. And she knows that she can't be driving up until that point, even though obviously in Northern Michigan, everything's extremely far away from each other, but she knows she has to obey the rules. She realizes she's getting a significant benefit from this plea. She appreciates that. But again, I would ask for fines and costs only. Thank you.
Thank you. Ms. Lawrence?
I understand sometimes lien doesn't always reflect the same things that a driving record does. But I did look at her driving record before coming up here, and quite frankly, it's getting a little bit ridiculous. As recent as this July, she had a driving while license suspended, and I believe she was pro per at that time, and I actually met with her, and she gave me the same spiel about trying to get her license back. I don't really have a doubt in my mind that in a couple of months, she will be back here again for driving without a license. I'm tempted to ask for 2 days of jail, quite frankly, in this case, but I will leave it up to the discretion of the court. Thank you.
What brought her to the attention of law enforcement?
Looks like she had no lights on.
What time of night or day was it?
Like 48 hours.
Ms. Wood, you had the right to address the court prior to sentencing. Is there anything you'd like me to know?
I know that I'm not supposed to be driving. I don't have my license. Like I said before, that it's been pretty hard for me to get it back. When I had got pulled over recently, they said that I couldn't get it back for another year. I don't really drive at all. And I have my friend drive me basically everywhere I go. So I shouldn't have been driving. I know that. And I definitely don't want to keep going back through or end up in jail for driving. So I'm definitely not going to anymore.
So if you knew you weren't supposed to drive, why were you driving?
I went to the store, to be honest. Didn't know.
Ms. Lawrence, I show, at least according to the driving record, this would be her 4th driving license suspended. Is that, you show that as well?
Believe so. I think the one I had was went down to an allow. I'm assuming.
Well, Ms. Wood, I don't know what to do because, you know, we got to do something to grab your attention. And I guess I would have hoped that the 3 prior times would have done that. Clearly it didn't. The court has to find reasonable grounds to incarcerate you as Ms. Lawrence wants. Recently, the appellate courts have tied the lower court's hands in imposing jail sentences for driving a license suspended. And I have to find this one more egregious than any other one. And it sounds like the reason for your stop was that you were driving without your headlights on at roughly 10 to 9 in the evening. I'm not sure that that gets us there. I can also take into account the closeness of the two events, one being in July and one being in October. And I can also infer from that that no matter what I do, you're not going to stop driving because you haven't stopped driving. Now today you've got a driver with you and good to you for that. But in the end, all it's going to take is you to decide to go to the store and you keep racking up these driving while license suspended. You're never going to get your license back. You probably just set yourself back 2 years to go to the store. I do find that there are reasonable grounds to incarcerate the defendant for the reasons stated, but I'll go through those again. She was convicted back in July of a similar offense. She was convicted in 2 convictions in 21 for a similar offense. While maybe the stop was not the most egregious, it was more than just driving without a license. Additionally, it does not appear that the defendant has learned her lesson from the most recent time and is likely to reoffend. So for those reasons, I find reasonable grounds to incarcerate the defendant. Sentence will be 15 days jail with 0 days credit. There is a $75 crime victims' rights fund fee and $50 state minimum fee. The court will waive court costs, fines. Mr. Hartel, attorney fee?
I would waive that.
Attorney fee waived. Ms. Wood, because I have sentenced you to a period of incarceration, you do have the right to appeal that decision. If you decided that you wanted to appeal it and could not afford an attorney to assist you, you have 14 days from today's date to request the appointment of an attorney. Also, any balance that remains unpaid for more than 56 days will have a 20% penalty added to that. You'll have to go with the bailiff. No.
Please.
No.
Ms. Wood. Ms. Wood, this way, the phone, I will grab it.